All persons having business before the Honorable Associate Judges now presiding over District of Columbia Court of Appeals. Draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good afternoon. We have one case on the calendar this afternoon, Walter Jackson versus the District of Columbia Department of Employment Services. And we are ready to proceed. Counsel for Mr. Jackson.
Good afternoon, and may it please the court. My name is Jonathan Ference Burke of Ropes and Gray. On behalf of the petitioner, Walter Jackson, I'd like to reserve 3 minutes for rebuttal. Your Honors, the CRB erred when it held that it lacked authority and jurisdiction to review Mr. Jackson's claim that he did not agree to a final settlement. Even when both parties have counsel, the CRB always has authority to review whether there was a settlement in the first place. Section 32-15-21-01D1, which requires the CRB to review a compensation order for legal sufficiency, gives the CRB authority to review a claim like Mr. Jackson's that goes to the existence of a valid agreement.
Counsel, when you say that your client contests that there was an agreement, are you saying that your client's argument is that there was not a meeting of the minds, that he didn't understand the nature of the settlement? Or are you saying that his claim is that he didn't actually see the settlement and sign it, or something else?
It's the latter, Your Honor. Mr. Jackson has been very clear that with respect to the workers' compensation settlement agreement that's in the record, looking at record page 35, that signature, which appears very irregular, it looks like it may have been lifted from another document. Mr. Jackson did not sign the workers' comp agreement.
What did he sign?
I'm sorry, are you saying that the signature is forged? Or are you saying that that certificate of service was attached to a different document and then borrowed for this purpose?
So, Your Honor, I think that's exactly what a targeted remand from the CRB to the OWC would have cleared up. There is something irregular about that certificate of service, just looking at it. But Mr. Jackson has been very clear. He did not sign, did not understand, did not reach agreement regarding the workers' comp settlement that's in the record.
I'm sorry, I just want to make sure I understand. What is it that's irregular about this signature? That the fact that there's not a signature from the employer with it, or?
No, Your Honor. Looking at page record 35 and then comparing it to record 34, it looks very much like things have been pasted on top of each other there on that signature page. The line for Mr. Jackson's attorney appears to be over Mr. Jackson's line, which isn't next to the employer's counsel's line. And again, that's not the entirety of Mr. Jackson's claim, because he's been very clear he did not agree to this. But I think the fact that it looks like that signature may very well have been lifted from another document that Mr. Jackson signed confirms his claim.
Well, that's his whole argument, isn't it? That he did sign something with the signature that is his genuine signature, but it's not a signature that he affixed to the piece of paper to which it purports to be a signature. Isn't that his argument?
That's exactly right, Judge Stedman. Mr. Jackson concedes that he signed something. And again, the record is unclear. That's exactly what a targeted remand to OWC could clear up. To the extent that the record is just unclear as to exactly what he may have signed, we just don't know right now.
But how, maybe this is also extra record. What I'm trying to figure out how he would have gotten the any document to sign other than through his counsel?
I think, Your Honor, there were certainly other documents that were signed over the course of this case. Looking at record 31, which is the settlement agreement, that appears to indicate that there was potentially a settlement agreement in connection with the third-party case. But again, it's all just unclear on the record, and that's exactly what a simple ALJ hearing could have taken facts and said, okay, how did these signatures get here? Is this truly a case where there's just no contract, it's void ab initio? Mr. Jackson never agreed to it.
Right,
Since
but you
you-
see where I'm going with this. I mean, on the one hand, you know, I understand why you would want to focus on, you know, whether or not he signed the agreement, because I think under 1508, you know, whether or not he agreed to the, you know, terms, I think would be a tougher argument for you to make. But I think under 1508, the CRB seems to have an obligation to assess whether or not he signed it. On the other hand, if he's represented and everything's going through counsel, then arguing that he didn't sign it seems like a backdoor way to get into these legal malpractice claims that the intervener and the district are telling us the CRB really has no business considering. So I'm trying to sort of suss that out.
Absolutely, Your Honor. And I think, again, this admittedly is not a common fact pattern. The closest case that DOES identified in their brief is Burton. And in that case, the CRB said it had authority to send the case back to OWC and investigate the validity of the settlement agreement.
Well, it wasn't the validity of the settlement agreement, right? It was the validity of the signature, no?
In Burton, the specific issue was the validity of the signature of the correct party.
Right. And so, you know, if you can make the argument that your client didn't actually sign this, Burton would seem to support your claim for a remand on that limited basis.
That's right, Your Honor, and that is Mr. Jackson's position. This settlement agreement here, this signature that was affixed at record 35, his attorney, he says, did not have his authority or agreement to affix it. That's at record 11. So that is his claim here.
So you agree that if his argument was, yes, I signed it, but I didn't understand it. My attorney fraudulently got me to sign it because he was so anxious to get his fee. Arguments of that kind would not work.
Absolutely, Your Honor. We agree with that 100%.
They absolutely would not work. The CAB is correct in saying, to the extent you are complaining about actions of your attorney, apart from maybe attaching a signature that's wrong, to that extent, the fraud, the misrepresentation, all that stuff is not relevant.
Yes, Your Honor. I think of that as
The whole case turns on, did he sign it? If he signed it, he's stuck with it. Okay, that makes it.
And if he authorized his attorney to attach his signature from that other page to the settlement, he's stuck with it.
That's correct,
And
Judge.
that's true even if he misunderstood what he had authorized his attorney to do, because, for example, his attorney didn't explain to him the settlement agreement clearly enough.
That's correct, Judge Glickman. That's, I think, the difference in under contract law between a void versus a voidable contract. If there was no authority, if there was no signature, there was no contract ab initio, it's void. That's a distinct legal situation from the cases like flood, like all of those out of jurisdiction cases that DOES cites, where it's Monday morning quarterbacking, it's sour grapes. Look, I should have gotten better advice. I didn't fully understand it. In this case, that is not this case. Mr. Jackson is saying, I did not agree to this, and I just simply, there is no settlement agreement.
And where does he say, where in what document does he tell the CRB, I didn't sign this? I understand that he's pro se, but I'm wondering where you would pinpoint that.
So, Your Honor, I think it's a couple of places. I think very clear at record 27, Mr. Jackson says, "I never agreed to the terms of the one-sided settlement. You do not have my signature."
I apologize, I'm looking at your appendix. So can you tell me where in that document it is?
Yeah, yes, Your Honor, I apologize. The record numbering is the same as the appendix. We filed the appendix because the record didn't have base numbering on it.
Okay, so what page number did you say again?
27.
All right, sorry, carry on, please finish your answer.
Yes, Your Honor, and record 27 is the letter from Mr. Jackson that the CRB construed as his brief. And he says, "I never agreed to the terms of the one-sided settlement. You do not have my signature on any approval statement." There are other documents in the record that Mr. Jackson submitted to the CRB as well, but this is just one of the examples.
So the CRB in its order says that the settlement, the lump sum settlement is signed by Mr. Jackson, right on the second page. Turning to the appeal before us, we note that the LSS was signed by claimant's counsel and employer's counsel. What should we do with that statement? Should we determine that it is clearly erroneous? Should we determine that it's unsupported? Should we?
I think it lacks substantial evidence in the record, Your Honor. But I think that admittedly the procedural paths here are a little bit potentially mixed up. But I think regardless of how you approach it, that's either a clearly erroneous, it lacks substantial evidence. It says that Mr. Jackson signed the settlement agreement but wasn't aware he was settling his claim. That appears to just be the CRB doing its own fact finding.
Well, here it's just maybe later they say, represent his argument that he didn't understand it, but here it's just a simple, we note that this lump sum settlement was signed by the three parties that it would need to be signed by to be compliant with 1508.
Your Honor, I see that I've exhausted my opening time.
Oh, well, please answer. If you had an answer to something just Judge Easterly said, please answer it, and then we'll hear from other counsel.
Well, Your Honor, I think that there's multiple ways to attack that. And the very least, it's certainly legal error to then extrapolate from that to then say that the CRB was barred, had no authority or jurisdiction to address the question in front of it. Whether it's lacking substantial evidence or it's clear error, those are all going to get to the same place of a targeted remand to figure out exactly what happened to the signature page.
But just to be clear, I mean, the jurisdictional statement that the CRB makes on the next page, you don't contest, right? The CRB says our jurisdiction does not extend to determining if claimant's attorney competently represented claimant before the OWC when settling claimant's case, or whether any misrepresentation occurred, right? So you agree with that statement?
Yes, as framed, Your Honor, the CRB certainly would not be the place for Mr. Jackson to bring a separate claim against against his attorney.
Okay.
All right, let us hear from counsel for either the government or respondent. I don't know who's going first, and we will ask you to tell us how you're going to divide up your time. And then you'll have 3 minutes in rebuttal. Okay, counsel.
Yes, absolutely. Thank you, Your Honor, and may it please the court. Ashwin Pathak for the District of Columbia's Department of Employment Services. And Mr. Emick and I have decided that I will take 8 minutes of time and that he will take 7 minutes of time representing the employer with the leave of
Very good. Thank you.
Thank you. There are two independently sufficient reasons why this court should affirm the CRB. First, the plain meaning of the text and structure of section 32-15088 requires DOES to approve a settlement where both parties are counseled, and in any event, the agency's construction is entitled to deference here. Second, the CRB is an appellate body like this court and cannot review new evidence or arguments not presented to the OWC. For that reason, the court did not err when it affirmed the OWC on the record presented to it, and where Mr. Jackson has presented no good reason for failing to raise his case before the OWC. If the court agrees with either reason, it should affirm. And I will just, oh, please.
I don't understand that second argument. The CRB had the power and authority to remand to the OWC on the basis of new evidence that was presented on appeal.
Well, the question, Your Honor, would, I'm sorry.
Yeah, so why does the second argument work?
Well, I think the question here would be whether a remand would have gotten anything from Mr. Jackson. And the reason that I think that it wouldn't have is because it appears that any remand would have been futile. And that's because for the 3 years between the time that the settlement was agreed to in 2016 and the time that it was submitted to OWC, Mr. Jackson could have raised any of these objections and didn't. And I understand that he
I
said—
know, but we can only affirm on the basis of the CRB's actual ground, which is the statute.
Well, I think the court can
Either
also
they're right
say—
about the statute or wrong about the statute. Everything turns on that, doesn't it?
I don't think that's quite right. Admittedly, the statute is one basis for affirmance, but I think you could also say that a remand, that any remand would be futile because
I would see why we'd get to that issue. What was your first point, though?
Sure, I'm happy to address the first point. So the first point is just that the statutory text here is clear. In conjunction with the structure of the statute, there's no basis for the—
Do you think that if the attorney had forged the client's signature, that the CRB would still be forced to affirm? Because on its face, it looked like his signature?
I think yes, Your Honor, and the reason for that is that— I'm sorry.
Essentially his case.
Well,
Say you have an agreement, it looks perfectly good, but the signature of the client was forged. And he says, I never agreed to any such thing. And would you say that this statute says, nevertheless, they have no choice, they have to affirm it, he was represented by counsel. If counsel forged a signature or didn't make sure it was a signature, tough, that's the way it is. I'm saying that's not an implausible interpretation, but are you saying that?
That is what we are saying, Your Honor, and let me explain why that is. The statute does not contain any exception for a situation like that, and it also would not be within the expertise of the agency to determine a forgery. So that—
Well, but the statute, I'm sorry, the statute says expressly, 32-1508, the mayor may approve lump sum settlements agreed to in writing by the interested parties, which seems to suggest that the mayor has to confirm that the agreement is in writing and agreed to by the interested parties, i.e. that it is signed by the interested parties. And that seems to be what the CRB did in this case, right? They confirmed this is signed by the parties, but then declined to go further. I'm not sure what the best interest review has to do with this case, right? Like, it all seems to come down to, did he sign this or didn't he? And the question is, did the CRB actually consider his argument, I didn't really sign this? And, did they have any basis for saying in their order that he did sign it? And it's hard to tell right now. So it seems at the very least that maybe we need to remand to assess that.
Well, I absolutely agree with you, Your Honor, that the agency does need to determine that the document is signed. And in this case, the document is signed on page 35 of the record. both the claimant's and his attorney's signatures appear on a document that says lien reducing order. And that is precisely what.
One of the things that I find so odd about this case is that this document that everyone seems to agree is the settlement agreement doesn't actually seem to have been drafted by the parties or their lawyers. It seems to have been drafted by the OWC. It's very odd, but everyone seems to agree that this document that's in the record and in the appendix is the settlement agreement, or at least memorializes the settlement agreement. Is that?
I agree
Is that
that
right?
that is everybody does agree to that, and there doesn't seem to be any additional information in the record to really address that point that you just brought up. Everybody has, including Mr. Jackson, has operated on the assumption that this is the settlement agreement that the parties agreed
Isn't that
that their
because,
attorneys signed.
isn't that because the settlement agreement turns into a compensation order? Therefore, it's a compensation order that is the final document.
That's right. I mean, that is what happens once the
So he's saying, I
OWC.
didn't sign the compensation order. That's what he's saying, I think.
I thought his claim, my understanding of what his claim is that he never signed the agreement to begin with, let alone any subsequent approved OWC order.
Isn't the document that he says he didn't sign is the compensation order?
We don't have any
You don't
other
have
agreement
any
in the
agreement,
record
no.
besides the compensation order. So
he seems to be suggesting, right, that he didn't sign that document that where his signature appears on page 35 of the appendix, which is
That's what the CRB and everybody else is relying on, is
Right.
that signature.
right.
Actually, in theory, I suppose, even if he didn't sign it, you still could have agreed to it.
I'm sorry, if he didn't sign it,
In theory.
in theory, that's
In
right.
theory, even though he didn't sign it, the
But-
other side could say, he didn't sign it, but he agreed to it.
In theory, that's correct. In practice, the OWC does look for a signature from the claimant, which exists in this case.
They do.
Mr. Fatak, I'm sorry, John.
Yeah.
Mr. Fatak, I'd like to test your interpretation of the statute as saying that even if the claim is that the signature was forged by the attorney, that claim is for someplace else. The CRB cannot grant relief. Suppose at the OWC stage, when they're getting ready to issue the order, Mr. Jackson had come in and said, wait a minute, that my attorney has forged my signature on that document. That my attorney has either that, or my attorney has, without my permission, attached another document containing my signature to it, and I'm not agreeing to this settlement. Now, suppose he had said that down at the OWC level. If the OWC said, well, we don't care. We've got the attorney's signature on this, and we've got your signature on this attachment that says that you signed. And if you don't like that, go, sue in Superior Court or something. But we're issuing a compensation order. Would that have been proper in your view?
I think it would
And
have.
could the CRB have said on appeal, no, wait a minute. You've got to, you can't, it's one thing if you don't believe him, but it's another thing if you say you don't care whether he's telling you the truth or not. Is that how you think this works?
Well, so this is a little bit difficult because the OWC is, when a settlement agreement that's signed by the parties and the attorneys comes before the OWC, this is not a situation where you have an ALJ that is.
I understand.
This is a claims officer that may not have legal training, definitely doesn't have the ability to, the expertise to be looking at forgery claims.
He certainly has the ability to say, I'm not approving this, when you're telling me it's a forgery. That doesn't take legal training or the ability to take evidence or anything of the sort.
The statutory text does seem to suggest that where both parties are represented by counsel and the agency is presented with an agreement that is signed by the claimant and by both attorneys, that is a situation where the statute says that the agency shall approve that.
No matter how obviously wrong and stupid that would be.
Well, I think there are some extreme situations, like for instance,
I thought I gave you one.
well, there's a smiley face on the signature line or something like that, where there's no indication that a particular party even, what was a party to any discussion of settlement, was part of any negotiation at all. The way the OWC operates now, I can tell you as a practical matter, is they do look for an actual signature from the claimant and from both attorneys before they approve an agreement like this. But the hypothetical that you're presenting is one where the party comes in and says, this signature that's on this document, that is my signature.
Yes, that is my hypothetical, because I want to know where you stand on that hypothetical before we get to the next stage of why this case would be different.
Well,
I don't think it is. That's why I obviously asked you the hypothetical. But
well, the problem with that is at base, what that claimant is suggesting is that their attorney is committing gross malpractice there by appending.
maybe, what if the attorney admitted it? What if the attorney said to the OWC, you're right, but I did sign, but his signature's there. That's my signature as well. Approve the settlement. It's true, he doesn't want it. It's true, he hasn't authorized this, but I know what's better for him than he does. Or whatever,
That seems different to me. That's a situation where the attorney is saying the claimant didn't agree to the settlement, but I'm submitting it anyway.
So if the attorney says he didn't agree, then that's that's grounds for relief. But if he comes in himself and says I didn't agree, that's not grounds for relief?
I think that is correct if his signature is appended to the document. And the reason for that is because, if it was a different rule and you said that a claimant could at any time after everything has been signed and submitted, come into the agency and say, well, hold on a second, I don't agree to any of this, actually. I didn't agree to that. This is all a forgery. It's fake. My attorney committed fraud. That really is opening the door to claimants who have buyer's remorse, who, a case kind of like this one, 3 years later, when
It would take a pretty gutsy claimant to come in and do all that. I don't think, it strikes me, to say that's opening the door to a flood or any quantity of cases like that strikes me as so far-fetched, frankly.
Well, I think we are dealing with a pretty rarefied sort of group of cases to begin with. It's not like this type of issue comes up every day, but I do think it opens up the door for claimants that, may down the road not, like the terms of an agreement that they did agree to come in and make potentially outlandish claims about.
Well, the thing about outlandish claims is they have the ability to be disproved. The attorney comes in and says, what are you talking about? And the attorney is credited and maybe has evidence to support it.
Again, I agree with you. I think, claims like that can be resolved. The question is where, and we would just respectfully submit that the right place for that dispute is a malpractice dispute in superior court.
Well, what if the attorney doesn't have malpractice insurance? Or what if what if there's some basis for, and bringing a lawsuit, a malpractice lawsuit, is an expensive proposition, time consuming, difficult. And meanwhile, you have this claimant who, the workers' comp law is supposed to be looking out for, sitting there, without, a satisfactory resolution.
I agree that it does raise the bar a little bit for proving a claim like that. But in the hypothetical that you suggested, where an attorney just appends a completely unrelated signature to an agreement that their client never agreed to, that's an open and shut case. That is not difficult to prove. That the client could get attorney's fees. Any attorney fee that was already paid out to their attorney could be used as compensatory damages for anything that they may not have been able to get through the settlement.
Well, it might not be so difficult to prove, or it might not be so easy to prove. The attorney can come in and say, my client authorized me, and it becomes to do that. He was, indisposed. I couldn't get him to come in and sign another document, but he said, just attach that one. And
Well,
I did. You know, but you think this case is distinguishable from Bruton?
I do, and I can.
Excuse me, Burton.
Burton, yes. Yes, I do think it's distinguishable. And that's because in Burton, what was at issue with whether or not a particular individual was the party that should have been litigating that dispute at all. So I think there is actually a textual basis for a remand in that case to decide whether or not the woman who is attempting.
Well, there is a factual distinction, and one can argue about how material that distinction is. But the way in which the CRB in Burton explained what its authority was in circumstances like this cuts against your argument and cuts against what they did here. And it raises the question whether at a minimum, the CRB should be required, if it's going to stick with this position, in this case, it should be required to explain how it distinguishes Burton or why it's deviated from Burton.
Well, I actually think Burton is quite different because there you're trying to decide, you know, this particular sentence in the statute says that the agency shall approve a settlement where both parties are represented by counsel. There was actually a dispute about whether or not the particular individual was the party that should have been resolving this dispute on behalf of an estate in a workers' compensation claim. So that's well within the expertise of the agency.
Well, it was a question whether that person was the party was either the decedent or once he was the decedent, I suppose the estate of the decedent. The party the party may or may not have been a proper representative. I mean, the person who signed may or may not have been a proper representative of the estate. But
right.
There's no question that the attorney there was representing the proper party.
Well, there's no question that the attorney was representing an individual, but there is a question about whether that individual was the proper party. And I think that's the key distinction.
Well, the attorney's client, when I say that, I mean the attorney's client was the estate, not the particular individual who was the personal representative of the estate.
Right, but the remand was right, but the remand was to decide whether or not that individual was the correct individual to be representing.
Right, the remand is to decide whether what we have here is the client's proper signature, and that's the same thing as is true in the present case. Do we have here the proper signature?
I think
in each case there's a claim that we don't, and in that case, the CRB said, "Well, we'll remand and let the OWC make a determination." And it seems inconsistent to say here we won't remand to let the OWC make a determination. And that's the way I'm sort of thinking about Burton in this case.
Can I ask you, where does the signature requirement come from? You said that as a matter of practice, the OWC checks signatures. Is there a regulation that, because the statute doesn't say anything about signatures. Statute says the mayor can approve lump sum settlements agreed to in writing by interested parties, where, and I'm eliding, the mayor determines it's in the best interests of the injured employee, and then the mayor shall approve the settlement, presumably the settlement agreed to in writing, where both parties are represented by counsel. It doesn't say anything about signatures.
I agree with you, Your Honor. It doesn't say anything about signatures, and I don't see an explicit signature requirement in the statute. It's not clear how else you would determine that both sides have agreed to the terms of a particular document. I mean, that's just sort of a matter of legal course basic contractual agreements. And so I think—
Is there a regulation or anything, or no?
I'm not aware of one that specifically has the signature requirement, but I that is, as a matter of practice, how it works. That is certainly how it's been working during the pandemic, for what it's worth to this court. That when
they checked, I'm sorry to cut you off. When they check signatures, where parties are represented by counsel, are they checking signatures for both the represented party and counsel, or are they just checking signatures for counsel?
My understanding is that they are looking for a signature from the claimant as well, as a matter of practice, that is how it works at OWC. Yes.
Okay, let us hear from counsel for the respondent, and that's Mr. Emig. Thank you.
You're muted.
Mr. Emig, you're muted. You have to unmute.
Court's indulgence. May it please the court, Jared Emig on behalf of the interveners, Trulin and Hartford. Judge Easterly, just to answer your question as to who wrote that agreement, the agreement was prepared by Mr. Beal and by myself. That's the form that we typically use in submitting settlement agreements to the OWC, and it's converted to an order. I'd like to briefly address the statute.
So there's no separate document. Sorry to interrupt you. That is the agreement.
That is the agreement, Your Honor.
Okay, thank you.
Just a matter of form. You know, I look at 1508, parens 8, and I try to figure out what is the purpose of the statute because it was a change in the law. And I think it's a shift. It's certainly a shift of responsibility to review settlement agreements. And what is the benefit? This is a benevolent act to claimants. And what benefit is bestowed upon a claimant? And the benefits that bestowed is it's a speedy, quick resolution of a settlement, and the claimant can reap the benefits of the settlement agreement. Now, with every benefit, there's some burden. The claimant loses the benefit of this independent scrutiny, but there's some protection. There's a lot of protection for every claimant because they're represented by an officer of the court, of this court, that took an oath before this court to represent their clients zealously, honestly, and fairly. I think it's very unfair to Mr. Beal to be accused by the petitioner at this stage that he forged an agreement. You know, I certainly don't want to go off the record, but I have a transmittal letter. I have a better version of the settlement agreement clearly signed by the claimant. And now to conjure up this argument 3 years after the settlement agreement was reached.
How do we know that the settlement was agreed to 3 years prior to it being approved by the OWC? I mean, I can see that the settlement, refers to a discontinuance of temporary total disability benefits as of February of 2016. So one could infer, okay, this is drafted before that time, and that's an outside date. But other than that, we have no idea when the meeting of the minds occurred, do we?
I certainly do, Your Honor, and I'm trying not to go off the record. I can tell you.
Right.
Your Honor,
Based on the record materials, we do not have anything, right?
Right, other than,
Okay.
The record does reflect that there was a pending appeal. Mr. Jackson, his benefits were terminated for failure to cooperate with vocational rehabilitation. We had a hearing before an ALJ, and the ALJ found him not to be a credible witness, and his benefits were stopped. He appealed that, and while the pendency of the appeal was there, we had a global mediation, and this is where 1508 comes into play. It's a complicated process trying to settle a third-party case and to address a workers' compensation lien. Because at that point, my client had a right to recover $288,000 from any settlement in a case filed by the petitioner against a third party. We had 2 mediations going on simultaneously at Mr. Beal's office, and Mr. Jackson was there. Back and forth all day, and we finally reached a settlement whereby my client would forego about $163,000 of its lien, and that money went into Mr. Jackson's pocket. I've asked petitioner's counsel rhetorically, is he going to give the money back? He spent that money and it's gone. We reached the settlement agreement. Mr. Beal and I prepared the settlement agreement. My client forborn, gave up $163,000. Following that, Mr. Beal returned the unwaived portion of the lien from the settlement with the third party. He paid it to Hartford, $120,000. And then they acted in accordance with the settlement agreement. They dismissed the appeal of the workers' compensation case, entirely tracking the settlement agreement. But there was a problem. During the course of the mediation, Mr. Jackson represented that he had never been a Medicare beneficiary. And that's important for a settlement of a workers' compensation claim because Medicare's interests have to be taken into perspective. My client ran a search and had a hit showing that Mr. Jackson may have been a Medicare beneficiary at some point. We embarked on a 3-year process working with Mr. Jackson's attorney, trying to get the appropriate forms to verify with Medicare that Mr. Jackson was no longer a Medicare beneficiary. This is not a case where we just stuck the settlement agreement in the file and woke up 3 years later. Once the Medicare issue was resolved, I alerted Mr. Beal, who was still counsel of record, I'm now submitting the settlement agreement that you sent to me undercover saying, here's the settlement agreement signed by my client and me. I submitted it to the OWC. I sent a copy of it to Mr. Beal and to Mr. Jackson. 10 days elapsed and Mr. Jackson made no objections to the Office of Workers' Compensation, raising fraud, raising forgery, and it was approved. It was approved, and that's really a critical point. It was approved in the absence of any objection from the very person charged with making sure that this was in the best interest of Mr. Jackson, and that was Mr. Beal. There's no objection filed. There's no record of Mr. Jackson calling the OWC saying, that's not my signature. He then goes forward and files his appeal to the CRB, and depending on which letter you look, he claims a lot of different things. He admits to signing it, but he thought it was for tentative money, which I don't know what that means. He claims he wasn't paid certain workers' compensation benefits. He claims he didn't understand it. He claims that he didn't know what he was signing. But that's not from the OWC record. That is something that he's submitting to the CRB, and the CRB is constrained to approve this on the OWC record, which it did. There was no request for a remand. The only request was that the CRB explore this. The CRB is not a fact-finding agency. So when it's looked at from a different perspective, I think the OWC did exactly what it was charged to do under the statute.
Problem is that the CRB, I mean, that was exactly the thing that went through my head, which was, is the real issue in this case whether or not Mr. Jackson did get notice of the OWC? If he did get notice from the AWC and did nothing, I can see a very good argument that he effectively agreed to it, he waived it. The problem is that that is not the ground on which the CRB ruled. It ruled on the grounds of the statute. It didn't say, you brought up this claim belatedly. It's too late. And what's more, we're not going to remand it. But they relied on the statute, and we cannot affirm on other grounds. We can't say, oh, well, he waived it because he was properly served, which also seems to be debatable. Even the government says they're not sure whether or not, in fact, Mr. Jackson was served. He says he never knew anything about it. The first I ever heard of the thing he says is when I got the order itself or something like that. And as soon as I got it, I then went in Baltimore to Washington and found out how to appeal.
Well, I think the point is that he is represented by counsel.
Not at that point.
Well, he was at the point that that the OWC handled the, or was reviewing the settlement agreement. All notices went to counsel. And that goes back to my original point that under 15088, the responsibility for policing this settlement agreement for the best interest of the claimant was assigned to his attorney. So now Mr. Jackson can say, well, I should be taken out of that class because my attorney has since withdrawn. At the time that it was before the OWC, this case felt squarely within the parameters of 15088.
I hear you talking, but that is not the ground on which the CRB went.
Well, I think the CRB pointed out that they applied the statute and they said it's signed by counsel and it's signed by the claimant, by the parties.
That's the issue.
So, counsel, earlier you were talking about how 15088 is the product of an amendment. And you said something about it allowing speedy relief, which doesn't seem to be what happened here. Nothing was speedy about this case. But I guess I was conceiving of the whole settlement process as kind of an off-ramp from the general workers' comp system, right? Generally, if you, are injured, you are presumptively entitled to benefits if you're injured on the job, and the way those benefits are given to you is, on a weekly or bi-monthly basis, right? You get your average weekly wage, or right. And so by taking a settlement, you're opting out of that sort of safety net by saying, no, actually, I'd prefer to get the lump sum. And then we have this additional layer of security where the mayor has to make sure that that settlement is in your best interest, unless you're represented by counsel, in which case we defer to someone who's hired a lawyer to act in their best interest and represent them in figuring out whether or not they should settle. I don't know if that squares with your understanding of the statute or not.
Well, Your Honor, I think there has to be an appreciation of the purpose of a settlement. Settlements oftentimes resolve disputed claims, and it's part of the Workers' Compensation Act, and it's a way to pay benefits to a claimant, and it's a way for the employer and carrier to buy their peace. So we often effectuate settlements when there's a disputed claim, either on accidental injury, nature and extent of disability. And that's where at this juncture, this case, when we had the mediation, there was this third-party case pending. Mr. Jackson wanted to put more money in his pocket, and the only way he could do that was by getting my clients to reduce their lien, because that was their money from the third-party plaintiff. Coupled with the fact that at that stage, Mr. Jackson's benefits had been terminated because my client was providing vocational rehabilitation services, and Mr. Jackson failed to cooperate. So Mr. Jackson was not entitled to anything but medical benefits at that point. So when it's looked at in the facts of the case, this is a settlement that certainly inured to the benefit of all parties to the case, because it allowed Mr. Jackson to walk away with $163,000 of my client's money, which is gone, will never be recouped. And now he wants to reopen his claim, have his buyer's remorse, and want more money when he's previously acted in accordance with the settlement. Does that answer your question, Your Honor?
I think so. The statute also talks about that where someone is represented by counsel, the counsel has to be eligible to receive attorney's fees under 325030. Would that be a basis to challenge an agreement before the CRB to say, well, actually, my lawyer wasn't eligible to receive attorney's fees or was trying to get fees above the cap that's set under the statute? Would that be a basis to seek review?
I don't think so, Your Honor, because in the settlement agreement that was submitted, Mr. Beal.
Not in this case, I'm just saying hypothetically. Sorry, I know in this case, the lawyer was not seeking any fees at all from the workers' comp matter, right? Or that's what the OWC order says.
Because he was able to get. He was able to
Right,
get.
he got his fees from the third-party lawsuit.
Third-party
but-
case.
Theoretically, would that be a basis for challenging a settlement?
I don't know, Your Honor. That's a good question. I've never seen that because, it's, to be honest, it's kind of a closed circle of attorneys that do DC comp. And, you tend to see the regulars over and over, and they all seek fees. I mean, rightly so, they're providing legal services. I know claimants' attorneys are required to submit a retainer agreement showing that they've been retained by the claimant and that they're seeking a fee only if it's approved by the Office of Workers' Compensation. So I'm sitting here trying to think of a factual scenario where there would be an attorney not entitled to seek fees in a workers' compensation case, because I've never seen that.
Okay. Did you want to add anything before we?
No, Your Honor, I think between the District of Columbia and myself, we've covered everything. Thank you.
Okay, thank you very much. Mr. Freshberg, give you 3 minutes for rebuttal.
Thank you, Your Honor. And I just want to cover 2 points. First of all, this court and the CRB do not find facts. That's the purpose of a targeted remand. The OWC can get the ALJs and hold a brief hearing and figure out what happened here. Mr. Emming may be right. My client disagrees, but that can be resolved with a fact-finding hearing. Second point, Your Honor, is to address something that the district argued regarding the scope of the remedies and where you might be able to seek them. Looking at section 1522 of the code, 1522D appears to require Mr. Jackson to pursue this claim throughout the agency and up to this court. And I mean, that makes sense because look, if Mr. Jackson says this is not a valid agreement, I didn't agree to it. If he doesn't do that, then this agreement has the government imprimatur on it. It says it's final, it's got the government stamp. And then we're going to face a much higher burden where Mr. Jackson would have to prove other things, go file in Superior Court if he wanted to challenge it.
How do you respond to the argument that the OWC is not an adjudicative body like, for example, the Office of Administrative Hearings or ALJs are, and is not set up to engage in the kind of targeted fact-finding that you're calling for on remand?
So I think, Your Honor, the OWC certainly can find facts. Going back even to this case, looking at the earlier appeal that Intervenors Council was referencing, there were facts found regarding Mr. Jackson's compliance with vocational rehab. And so this doesn't seem to be outside the ken of the ALJs and the nice folks at the Workers' Comp office that could just reach a simple fact finding. Unless there are any other questions, Your Honor, we would ask that the judgment of the CRB be vacated and remanded.
Okay. Counsel, thank you all very much. The case is now submitted.
Thank you.
You are excused and you may log off.
Thank you, Your Honor.
This court is now adjourned